Okay, and that's the point I was getting to,
Okay.
okay? And really, I have no intent to argue with you, okay? Now, you said you started seeing some red flags in the relationship, is that correct?
Yes.
Okay, and the red flags, I would imagine, were, some verbal abuse and the like?
That too.
Okay. Now, by the time you're having your baby in June of 2010, you stated that you made a decision to not have Otis there. Is that accurate?
That's right.
Okay. And so, just in specific factors, did Otis know the baby was due on a certain date on June the 2nd of 2010?
Was new? Like he was born?
Yeah, did he know, hey, I'm going to the hospital to have the baby?
Oh yeah, he was aware. That's why he wanted to come over and see the baby.
Okay, and I gather, did you tell him don't come, or how did, I'm trying to figure out, how did it come that, he wasn't welcome, I decided this, how did that come about?
Well, he eventually he did show up to the hospital, but it was like along the lines when I was there, I didn't get a chance to talk to him as much, but my family did. So I guess given the fact what was exchanged between the two parties, that it wasn't really a welcoming atmosphere.
Okay, but you said, and correct me if I'm wrong.
Go ahead.
I thought you said that you had made a decision prior, I guess, to going to the hospital to not have Otis there, but to have a family member there.
Oh, yes, that too, and not to let him be in a delivery room with me.
Okay, and I'm trying to figure out, how was that conveyed to Otis?
It was just that seeing as he didn't really show up during the time where I had to make appointments when I was pregnant,
Yes, ma'am.
so I usually went to the appointments by myself or another family member. So it just proved to me that he wasn't willing to put much effort.
Okay, but for June the 2nd of 2010, did you tell Otis, you're not welcome in the delivery room, don't come over here, whatever the case might be?
I told him that he was not welcome to the delivery room, don't come.
Okay. And then we know that subsequent to that, at some point, he showed up, correct?
Oh, he did show up,
Yeah.
and he wanted to see the baby for himself.
Yes, ma'am. And do you know from the time of delivery or from June 2nd, was it the same day that he showed up, or was it a day later, or what? Do you know?
I would say it was a day later, I remember, because he was holding the baby.
Okay. So he did get to carry his baby and like.
Yeah, he got to get a chance to look at him, hold him.
Now, subsequent to that, he did offer to live together with you, correct?
Well, he asked my parents.
Okay. And of course, we've met your parent, your
Yes.
father, I'm sorry.
Yes.
And I guess they told him no?
Yes, he declined, even though he mentioned that he was willing to pay about $200 or so to move in, because at the time he didn't have a place to stay. He was kicked out.
Now, you said at some point he did get you all an apartment, or get you an apartment.
Oh, he got an apartment. We got the apartment.
Okay. And you said that it just didn't work out. He offered for you to have the apartment or something like that?
Like, he invited me to come over to the apartment so we could spend more time with his son. However, I just didn't feel comfortable, like, moving in or even staying for very long.
Okay. And did you in fact visit him with the child at the apartment?
I did visit so I could take a look around and see, like, what's around.
What the setup was?
Yes.
And do you recall how many times you visited?
More than once. I just, like, it wasn't too many, like a few times here and there.
Okay. And so I guess you declined the offer?
Yes, I declined.
Okay. Now, subsequent to that, you stated, the things escalated and maybe you started getting physical and I'll continue the verbal, correct? That's your testimony?
Mm-hmm.
Okay. Is that a yes?
Yes.
Only because you can't take
Okay.
So, did he, and I believe you testified yesterday, that he did in fact want to see his child, correct?
Yes, he did.
And So, when did he start getting, to see his child? That you can best recall.
Like after he was born.
And, okay. And in what way? I'm trying to figure out how much, visitation or time he could spend with the child.
Got it. It's just that I would have to take my son over for him to see him for a bit, to visit. He was usually, the son was always with me.
Yes, ma'am, of course. And where would you take your son? Don't tell me your son's name. I know that. Where would you take your son to visit with his father?
At his mother's place, if not the grandmother's.
Yes, he testified to that.
And if not, it would be his apartment. But most of the time, it was at his mom's or grandmother's.
And how often did that happen?
Frequently. Well, I was there frequently, but it just, I can't give you a certain amount, but it was just usually whenever he's off or before work.
Okay. And at this time, is Otis working?
At certain times he was working, but okay. It was certain times. At times he was working, at times he was not, or at times at the time he didn't have a job.
Sure.
So it varies.
Do you remember, other than McDonald's, what other places did he work that you recall?
I know there was a place downtown that he worked with the newspapers.
Mm-hmm.
There was also a bakery, a couple of bakeries, I believe.
Did he also work at the Lone Star Bakery?
Yes.
I think, right?
That's right.
And did he work with the sanitation department with the city? Did he do that? Do you know?
I'm not too sure. I know it was another place too.
Okay. But it appeared he was trying to have gainful employment.
Yes.
Okay. And during this time, was he, at this time right now that we're talking kind of, how old would the child be?
I would say like very young, like toddler.
Okay.
Or perhaps around ranges from when he was a baby to a toddler.
Okay. So we know that so we know that at some point an order, legally it's called a final order in suit affecting the parent-child relationship. That was entered on September the 26th of 2011. Do you recall that? Mm-hmm. Is that a yes?
Yes.
Okay. And so prior to that, was Otis trying to help you financially?
He was, however, it just seemed like it wasn't steady. He wasn't able to manage to keep a steady income.
Because he was going in and out of jobs and the like.
Yes.
Okay. And when this order, and sometimes private attorneys do it, and sometimes the Attorney General does it. Did he place himself on the child support with the Attorney General?
That he was placed.
Okay. Well, yeah, it's a court order, a judge orders it. And And it was an agreed order, right? So both of you agreed to this order?
Yes, because we both showed up.
Yes, ma'am. And this order determines, amongst other things, child visitation is one of them.
That's correct.
And of course, the child support is another one, right?
Yes.
Okay. Now, to the best of your recollection, how much was the monthly child support?
It should be about, in the beginning it was about like 131 or so.
Okay. And do you recall what the visitation was?
I believe with the visitation, it was the 1st, 3rd, and 5th of Sunday.
Okay. And Mr. McKane was also ordered on his current child support to pay $223
Okay.
a month. You know, I know it's a long time ago. And then the visitation, though, most court orders, it appears to be that this one is similar, is that a father gets to have visitation with a child the first, with some exceptions for summer and Christmas and stuff like that, but the 1st, 3rd, and 5th weekend of each month, right?
Right.
And most court orders are from, like, I guess 6 o'clock on Friday to 6 o'clock on Sunday. And are you aware of that?
Yes.
And is that what the court ordered in his case?
To his, yeah.
Okay. And so let's talk post-September 26th of 2011 when this order was entered. You know, how many times did Otis take your child for the weekend?
As long as he was off work, I remember that he would take him, like several. I can't give you an exact
Sure.
per se.
You know, let's just say, I mean, you know, in a month, I know it's 1st, 3rd, and 5th, right?
Yes.
Really, it's mostly 2 weekends a month. And so I guess in 2 months, he should have had the child at least 4 times, 4 weekends. Would you say that that was the average or not?
Just around that.
Okay. And at the time, where would you, let's say, deliver the child on that Friday at 6, roughly?
Usually the same place, either at his mom's or his grandmother's.
Okay. And then you go pick up the child on Sunday?
If not sooner.
Okay. And would there be a reason that you picked up the child sooner? It's like he's got to go to work or something like
Yes.
that? Okay. So in that respect, at the very beginning, things were amicable?
In a way, yes.
Okay. Now, you stated yesterday that Otis did in fact want to see his son and wanted to exercise his visitation, correct?
Yes.
Okay. And I believe the phrase you used, he was really trying to prove he could be a good father.
That was actually what he wants to prove to me and the family.
Okay. Now, if your father, when you met him, would have been under the impression that he didn't work, that could just have been a misunderstanding, because we know when you met him, he was working at McDonald's, right?
Yes.
Okay. Now, at some point, it's clear that he is going through a financial struggle at this period in time, right?
Right.
So yesterday, when you, getting back to the apartment, you know, you said he tried to get an apartment, but it didn't work out, and you said it probably because of money. And so it was that you couldn't afford the rent up to that apartment, even though you didn't move in.
Oh, that's what it seemed.
Okay. Now, if we fast forward a little bit, and I'm trying to take it a little bit in chronological order. So we fast forward from September to not too long after that, to February the 9th of 2012, and that's when the protective order is entered. Do you recall that?
Yes.
Okay. And and so we know you sought the protective order. It was awarded. Now, subsequent to the protective order, so now we're talking past February 12th of 2012. Now, how's visitation working?
It wasn't going so well because once we had the protective order throughout certain times, it would be violated.
Okay. And, violation of a protective order is a chargeable offense. It's actually a crime, and you can be charged with violation of a protective order. That never happened in this case, right?
Right.
Okay. And so, the visitation in particular, after the protective order, were you still delivering the child on Fridays at 6 and then picking up the child Sundays at 6?
Due to the fact that there was some reports at the time, it wasn't going as well as planned.
Okay. And so for I'm sure good reasons, various reasons, so you would not deliver the child pursuant to the court order on Fridays at 6 for various reasons.
Right.
Okay. Now, during this time, Otis is still trying to see his child, right? Even though there's other things going on.
That's correct.
Okay. Now, so yesterday we heard you testify about the event at McDonald's.
Yes.
Okay. And again, really, correct me if I'm wrong, but I thought you said that the visitation had to be at a public place and he had to remain there. You testified to that?
Yes, that's correct.
Okay. Now, because we looked and we can't find a court order that says that. So where did that idea come from?
It was with mediation.
Okay.
It should be.
And was there a paper or something like that that you had, that you carried, that says visitation should be in public and only in your presence or in the presence of, you said a supervising adult or something?
Yes, it was agreed on both parties.
Okay. We're trying to figure that out, but there's ways that lawyers have to look into the public record, and we couldn't find it. That's all I'm saying. I'm not saying that it's not true. We just couldn't find it. Now, having said that, this event at McDonald's, like any relationship on an argument, let's just say an argument, would you say that sometimes it's two ways,
At that time during McDonald's, it was more of a one-sided conversation.
Okay. And we know you said to a manager something called the police.
Yes.
Okay. And then you had subsequent time to call your father, right?
Before I went, yes.
Okay.
I went inside.
And so when he's in the parking lot, we heard that he was running around. He wasn't running around before your dad arrived. He just had his child in the parking lot, right?
To confirm that he was carrying my son, he left the building and he was carrying my son, and it appears that he was going to the bus stop to take my son away and just hold on to him.
Okay, now how did you come to agree to meet at McDonald's?
Like I said, it was during mediation. We both agreed that the closest public place was for him was McDonald's.
Okay. Now, Otis, you have any doubt that Otis loves your boy?
I'm certain that he does, but it's just based on his actions and how he's been with his behavior, it seems that he doesn't. And by judging by my child at that time that what took place in McDonald's, my son was crying and he didn't feel like he was safe.
Well, clearly when two parents, the voice is raised or whatever, I would imagine any child gets scared, right? And starts crying.
Actually, he was the one that was raising his voice, raising his tone.
Okay. And now, again, we don't know, I know you're saying mediation, but we haven't found anything that says that.
I object to defense counsel testifying, Your Honor.
I'll sustain.
Your Honor, I can ask leading questions. You can say yes or no.
You can ask leading questions, you can't
Okay.
testify.
Now, you can't produce to us the mediation document that you're talking about.
But I can confirm that I have been to mediation more than once.
Okay. More than once?
Yes.
Okay, so there's been more orders in mediation?
When mediation one was with Otis, and then the second mediation was with another family member of his.
Oh. So when you say mediation, you see, to lawyers, mediation, there's a mediation center over here in the civil courthouse, and there's like a retired judge.
I'm going to object to defense counsel testifying, Your Honor.
Yeah, no, let me get to the question.
Overrule that one.
So there's usually a retired judge or something like that hears two parties and then enters orders. You're saying that a family member mediated between the two of you?
For the first one, it was just with Otis. The second one was with one of his family members, yes.
Okay. Now, there was still a court order. The judge ordered that he had the right to the first, third, and fifth weekend, and that was still in effect.
However, there was also a protective order.
Yes, ma'am. And are you aware that the protective order did not change the visitation that Otis was entitled to?
Because it's saying
Your Honor,
that
object, that's stating a legal conclusion.
No, Your Honor, we read.
You can rephrase it. You can rephrase it.
Well, we read the protective order, and nowhere does it alter the first, third, and fifth weekend that Otis was entitled to. Are you aware of that? Just yes or no?
with the protective order, it had my name and my son's.
Now, you said that, the times that Otis lost his cool, if you will, that the prosecutor asked you, why did that happen? You said he was under a lot of tension, frustration, in his struggles, right?
Yes.
Now, the incident where we heard the recordings in the call, Otis is crying a lot, right?
Yes, and it appears that he also had a breakdown.
Yes, it's like a mental breakdown of the sort, right?
Yes.
And kind of indicative of a lack of coping skills.
The coping skills agreement does not things going away as planned.
Now, during the times when you said that you would go to drop off the child at Sandra McKane's household, and you said, I found out Otis was there, right? Something like that?
Yes.
Well, I mean, there was no court order. There wasn't any court order preventing him from being there. Are you aware of that?
Either way, I still had got my son back.
Say that one more time.
So either way, I was still able to retrieve my son back.
Of course, yeah. I mean, any father that has visitation, and you're the managing conservator.
And plus, there may have been a misunderstanding.
Yes. During some of the arguments, and I'm not talking specifically about the one in the car, that we heard the recordings and the like, but clearly this is a rocky relationship,
Yes.
to say the least. And were there times where you would raise your voice in arguments with him?
Honestly, not as much as he did. Sometimes I just try to calm down and keep my cool. Otherwise, if I would raise my voice and yell at him, it would just continue on and escalate with the disagreement.
Now, was there ever a time, and it's only a question, where you got physical with him?
Only because he got physical with me first. It was more than self-defense. I know one time with the incident of Walmart, for me trying to not having the money right then and there, and when he was attacking me and choking me, I had to defend myself.
Was there ever a time, an incident, where you threw some battery and it may have hit his brother or something like that?
Honestly, what does that have to do with this case right now?
Well, the question is, was there ever an incident where you threw a battery and it may have struck somebody?
I'd rather not say.
Well, you're on the stand, and some questions, I understand on privacy issues, and we won't get into that, I respect that. But that is an important question. Was there a time where you threw a battery and it hit somebody?
At that time, it was only just an accident. I will confirm that me and the other party have discussed this and apologized, and it was confirmed that we leave it right then and there.
Okay. In other words, it did happen.
I don't object to relevancy of this. It's not the defendant, there's no relevancy in this. They're trying to impeach her with specific acts of misconduct, so I'm
We'll
going to
draw the
object.
statement.
Well, then I'm going to ask the jury to disregard that line of questioning, Your Honor. And her
It's the one,
answer.
it's the one statement.
Sorry?
Thank you, ma'am. No further questions.
No, 390.
Your Honor, may I first?
Yes.
All right. Ms. Paye-Hill, I'm going to show you what's been marked as State's Exhibit 390.
Okay.
A certified copy of the cause number 2011 CI 08878. In the interest of your son, it has your name and the defendant's name on top. Is that correct?
Yes, that's correct.
And it addresses the visitation, the Saturdays, the first and third and fifth weekends. Do you recall that?
Yes.
And it also addresses child support from the defendant to you.
Yes.
Okay. Has the child support, I guess it's changed at some point to $223 beginning August 1st of 2011. Do you see that in this document?
Yes, I do.
Okay. And has your signature and the defendant's signature throughout, is that right?
That's right. Yes, okay.
Your Honor, this time the state moves to introduce State's Exhibit 390.
No objection, Your Honor.
That's admitted.
So defense counsel was asking you specifically about the visitation at a public place. Do you recall that?
Yes.
Okay. And you said it was part of either a mediation or part of a court order that required, when the defendant visited with your son, that it needed to be in either a public place or kids exchange. What
Yes.
is kids exchange?
Well, Kids Exchange is a safer place where you can allow both parties to show up and spend time with the child, minor.
Okay. And so that was part of this agreed court order, is that right? That the defendant, if he was going to see his son, needed to either do it through the kids program, kids exchange, or supervised. And it says supervised at all times. Can you tell us about that? I'm going to show. Looking at this document, State's Exhibit 390, do you see that?
Yes, I see it.
Okay. It says it's checked, respondent has committed family violence during the 2-year period before I filed this case. I asked the court to keep respondent away from the children, but if the court will not deny respondent visitation, I ask that the court order that respondent's visitation be supervised in the following way. And the what's written below it says kids programs, in parentheses, kids exchange supervised at all times. What was the purpose of having this in there?
It was just to due to the fact that there was escalation of family violence, domestic violence. It was best to have the kids exchange so it would be at a public place in a much safer environment.
This domestic violence that you're talking about, who was the victim in this domestic violence?
At the time with that, it would be me and then my son.
And you were the petitioner, is that right?
Yes, that's right.
And the respondent was the defendant, Otis McKane?
Yes.
And were you concerned for the safety of your son?
Yes.
And you were concerned for the safety of your son, by whom? Who are you concerned about?
I was concerned about myself. I was concerned about my son. Given the fact that if he was able to put his hands on me, who knows what he could be able to do to my son.
All right. And you said in the beginning, earlier in your relationship, you said that there were some red flags that had gone up.
Yes.
Okay, what were those red flags?
In the beginning, he did have a car, but at that time when something happened, and regard to that, it had nothing to do with me, but he was, by the time that we were supposed to go on a date and took me to pick me up, he just tended to blame it on me, as if I was responsible for him losing the car.
Okay. And so you talked too about some like verbal abuse that occurred?
Yes.
What specifically were you referring to? You said like blaming you for things that were out of your control?
Yes, such as when he wants me to take him to work, like I would have to literally drive all the way up to where he is to take him to his destination. If I don't arrive on time, he wouldn't like that. He would take that out on me verbally.
And when you said he would take it out on you verbally, what does that mean? What would he do? What would he say?
He would say, thanks to you, I'm late. That's, in an attitude, kind of way. Because he didn't like that he would arrive late to work, or he needs to go over to a certain place, such as picking up his check at a certain time, otherwise it would close.
Okay. And so if you weren't available, or if something was going on in your life, say your college classes, that would upset him because why?
It would just interfere with the schedule.
And so that would inconvenience him, would you
Yes.
say?
Yes, because I was his means of transportation, if it was anybody else.
And the protective order that defense counsel asked you about, you filed the protective order, and the defendant eventually agreed to that.
Yes, he did.
Is that true? Okay.
Yes, that's
And you
true.
filed the protective order because of the assault that occurred at the Walmart in January 22nd of 2012. Is that correct?
That's true.
And so then, and that's the same case that he pled to and got sentenced to 60 days in the Bexar County Jail. Is
Yes,
that right?
that's right.
Okay, that the jury saw yesterday. He was, Your Honor, may I approach?
Yes.
He was also on probation, is that right, for a drug case out of San Angelo when you had met him?
Yes, that's correct.
Okay. And possession of cocaine, is that right?
I believe so.
And so he was required to have a job. Do you know that as part of his probation or be gainfully employed?
I haven't really gotten into that, but I believe that's true.
And was he, you said to the defense when they were asking you questions about whether or not the defendant had head jobs or work full-time. Did he seem to be employed regularly throughout your relationship with him?
Yes, it seemed to be he was employed.
Okay, and was he paying child support regularly?
He wasn't paying child support regularly, but in the beginning it seemed like he was, but then it just declined. It just got less and less and less. It decreased, I mean.
Okay, and then you're saying in the beginning, you're saying what, so your son's born June of 2010, so the beginning would be at what point? In 2011 or so?
Yes.
So it seems by looking at these records, we can start with so the records from the Attorney General's office that have been introduced into evidence, States Exhibit 386. If we're looking at the dates, beginning July 1st, 2011, the balance, if we look on the right-hand column, it refers to the balance as to what's owed. And then there's medical support and there's child support. Do you see that at the top, Ms. Cayehill?
Yes, I do.
Okay. And so initially, you said in 2011, he's owed, he pays, the amount owed is $223. And then this column shows the amount applied, right?
Right, that's correct.
So if we kind of do the math for the year of 2011, he's paid about $400, a little over, maybe $420, $430 for 2011. And this 5608, these collections, are those coming to you? You said they came to you on a card?
Yes.
Sort of withdrawn from his salary, like garnishment or something? Is that, and it came to you or to your son?
It came to in the card too. Yes, in form of a card.
Okay. And then if we look here, so then in 2012, he pays, starting in January, several payments of either 5608 or 54, 41, 56, or in 2012. So then so in 2012, he makes a payment of $56 on February 3rd of 2012, 5608, and his next payment is in July. So he goes March, April, May, June. So 4 months without making any payments of child support to his son?
That's correct.
Okay.
Yeah.
So how is your son eating? I mean, who's paying for your son to eat, his clothing, his diapers, who's paying for that?
Check to the eating order.
It's an open-ended question. I'm asking who's paying for it. I'm not suggesting the answer.
Overruled.
Needless to say, it would be my parents. If not, I took it upon myself to depend on myself and to provide for my son. So I took on jobs, various jobs, temp jobs.
Okay. So then he makes some payments in July of 2012, and then in August, there's some more payments. And then he goes from August 27, 2012, until March 1st of 2013 without a payment. Do you see that?
Yes, I do.
Okay. And then after he makes this $1,466 payment on March 1st of 2013, and then he goes from that date until the next year, January of the next year, so 10 months without making a payment. And then we're at, January of 2014, where he pays $81.38 and $72.29. So right at, $250 after not having paid for 10 months? Is that correct? Is that what you see?
Yes, I see that. That's correct.
And again, who's paying for your son? Who's taking care of your son financially?
Like I said, it's myself. I could depend on myself more than just child support. Seeing as the results show for itself that it wasn't going as well.
So then we look at, that's January of 2014, another $565 payments made in March. of 2014. And then a payment's not made. So from March 21st of 2014 for a full year until March 26th. So a full year goes by without making a single payment from the defendant. Is that correct?
Yes, that's
According
correct.
to these records, do you have any reason to dispute these records from the Attorney General's office?
At this point, it did no longer bother me because at that point I was working full time and I took care of everything.
And is that something that you had gotten used to doing?
Yes.
So now we're at what, March of 2015, he makes the $194.25, April of 2015, $61.59 payment. And then after the April 10th, 2015 of the $61.59, he goes all the way to January. If we look down this column, all the way to January 19th of 2016, where after he pays $45. You see that after 8 months, then makes a $45 payment. So now we're in January of 2016.
Yes.
Then continuing to go through these records, then skips, doesn't make any payments for February, then March makes several payments totaling a little over $200. Do you see that in March?
Yes, I did.
Okay. And then pays $190 in May of 2016. In June, pays $190 and $161. And that's the last payment that he made. These two payments, June 3rd and June 20th of 2016, and then no other payments are shown for the support of his son, going all the way to, let's say, his arrest, November 2016. Is that correct?
Yes, that's correct.
You heard the defense attorney asking you, he asked you, did it seem like the defendant loved you and your son? Do you recall that specific question?
Yes, I do recall that.
And did it seem to you that the defendant loved you and your son when he had his hands around your neck choking you?
Even though he said it over and over a few times, whether by text, in person, or by phone, the actions proved otherwise.
And did it seem like he loved you and your son when he was threatening to kill you on
Objection to
multiple
leading, Your Honor.
occasions?
I'll sustain. You can rephrase it.
Well, when he was threatening to kill you, did you feel his love at that time?
It's a leading question again. Objection, Your Honor.
Overruled.
What I felt was the opposite of that. It was like I felt anger, I felt hate. It was definitely the opposite of love, not even close.
And when he was driving, when you were driving and your son's in the back on those tapes we heard, and he's saying specifically, I'll kill you, you're taking my life away from me, I'm gonna take care of you. You got to fucking believe that, dude. You got to fucking believe that. You got to fucking believe that. When he was saying that to you and he's grabbing the steering wheel with your son in the back, did you feel his love then?
Objection to leading, Your Honor.
You can ask her how she felt.
During that time, I felt scared. I felt complete shock because that never happened before. I didn't feel any love. I just felt terrified and frightened for what he did.
And when you described to the jury yesterday, when he punched you in your face and had bruises all over your chest, did you feel his love then?
Objection to leading, Your Honor, testifying.
Justice Bain, you can ask her how she felt during that time.
How did you feel during that time?
What I felt was pain, humiliation, grief.
I'll pass the witness.
Okay, I'm going to show you some portions of State's Exhibit 390,
Okay.
which the state showed you, and it has been admitted into evidence. So, where the state showed you, let me see this. You know what a petition is?
Yes.
Okay. It's what something files, someone files a document requesting something from a court. Generally, is that your understanding?
Yes.
Okay. In here, let me see, the part that the state showed me. It says, the respondent, etc. I asked the court to keep him away from my children, but if the court will not, this is what I'm asking for. I'm asking for the kids program, kids exchange, supervised at all times. So that's what you asked the court.
Yes.
Okay. So then, sorry. So then the court, on July the 11th, the 22nd of 2011, entered what's called temporary orders. You see the date right there?
Yes, I do.
Are you familiar with what temporary orders are?
Yes.
Okay, so it's just that while the lawsuit is pending and anything, even in family law, car crashes, whatever, a judge can enter temporary orders pending the finality of the lawsuit, okay? And it's ordering the parties to do certain things, okay? Is that okay? You agree with that? Okay. So then, as part of the temporary orders, again, sorry, what the judge said is, okay, you are to follow this possession schedule until September the 26th of 2011. Otis McKane is ordered to have possession on the 1st, 3rd, and 5th weekends of the month, beginning July 30th, 2011, as follows. Saturday and Sunday from 9 to 5 at his residence. There will be no overnight, and it's a higher Pilot Hill will drop off and pick up the child. So on the temporary orders, Otis is entitled to have his child the 1st, 3rd, and 5th weekends of the month. Saturday from 9 to 5, and Sunday from 9 to 5. Do you see that?
Yes, I see
Now,
that.
that's a court order. It's ordering you to do that, and it's ordering him to do that. You see that?
Yes.
Okay. It's not a request by a court. You agree with me?
I've seen the paperwork.
Okay. So that was in July the 22nd of 2011. Thereafter, you see this title, Final Order in Suit Affecting the Parent-Child Relationship?
Yes, I see that.
So that was entered on September the 26th of 2011. You see that?
Yes.
Okay. And then what the court ordered in that order, and it's an order from court to the parties, you and him. It said, after June the 2nd of 2013, until that time, Otis McKane is ordered to have possession on the 1st, 3rd, and 5th weekends of the month, beginning October the 1st, 2011, from Saturday at 9 a.m. to Sunday at 5 p.m. at his residence. So Hyatt Hill will continue to drop off and pick up the child. The possession after June the 2nd, 2013 is attached as exhibit. So what the judge is doing, saying, okay, from September 26th of 2011 up to June the 2nd of 2013, Otis had rights to his child the 1st, 3rd, and 5th weekend of the month. And he had the right to the child, not like the temporary order that said 9 to 5 on Saturday, 9 to 5 on Sunday, no overnight. That was the temporary. You recall that?
That was a temporary.
So the final order says, at least from September to June of 2013, he's entitled to the child Saturday at 9 a.m. all the way till Sunday at 5 p.m. You see that?
Yes, I do.
Okay. And again, that's a court order. It's ordering you to do that. You see that?
Yes, I see
Okay.
that.
So then we go to, it said something about a further order after June the 2nd of 2013. It says the visitation order is attached as Exhibit A. So you can just bear with me. Okay. So here's what's titled now Exhibit A. So this is the order that applies after June the 2nd of 2013. And it says that Otis Tyrone McKane shall have the right, Otis Tyrone McKane shall have the right to possession of the child on weekends throughout the year, beginning at 6 p.m. on the 1st, 3rd, and 5th Friday of each month, and ending at 6 p.m. on Sunday. Do you see that?
Yes, I
Okay.
see that.
So the court expanded the order. Instead of from 9 on Saturday in the morning to 5 on Sunday, the court expanded the order beginning June the 2nd of 2013 to Friday at 6 all the way to Sunday at 6. Do you see that?
Yes, I see that.
And the court ordered you to do that. You realize that?
Yes, I see that.
Okay. And by this time, the court is aware of the prior protective order. You're aware of that because that was prior to this, correct?
Yes, that's correct.
Okay. Now, the court also orders, under certain circumstances, that Otis can have the child from 6 p.m. on Monday, it looks like, until the school resumes, or till Thursday. Do you see that?
Can you bring that down?
Oh, sorry, again, I'm not. But let me move forward. Okay, in addition, the court orders that Otis Tyrone McKane shall have right of possession to the child on Thursdays of each week during the regular school term from 6 p.m. until 8 p.m. every Thursday. It's like a dinner date. Do you see that?
Yes.
The court ordered that. Spring vacation, the court ordered that Otis Tyrone McKane shall have possession of the child in even-numbered years from 6 p.m. on the day the child is dismissed from school until 6 p.m. until school resumes after that vacation. Do you see that?
Yes.
So it just gives the father the spring vacation with his kid. Do you see that?
Right.
Okay. And in summer, if he gives you notice by April the 1st of each year, Otis Tyrone McKane shall have possession of the child for 30 days, beginning not earlier than the day after the child's school is dismissed for summer vacation, and ending not later than 7 days before the school resumes at the end of summer. Do you see that?
Yes.
Okay. And the court ordered you to do that, right?
That's what it says in the paperwork.
Okay. And it says if Otis failed to give you notice in writing by April 1st, he is still entitled, and he shall have possession of the child for 30 consecutive days, beginning at 6 p.m. on July the 1st, and ending at 6 p.m. on July the 31st. Do you see that?
Yes, I see that.
And the court ordered you to do that.
That's in the paperwork.
Now, if I were to tell you, just generally speaking, that nowhere in this order does it say if the father does not pay child support, you don't have to give him possession. You're aware that there's nowhere in this order would it say that.
That hasn't mentioned about child support, you're right.
Okay. And so the idea behind that is if a father is behind in child support, you don't get to keep him from seeing his child. Do you know that?
I said.
I'm sorry?
I said, yes.
Okay. And because you have remedies for that. The law gives a parent remedy if a father is behind on child support. You're aware of that?
Yes.
But the remedy is not to keep the child from seeing his father. You're aware of that?
Even though due to his behavior and aggressiveness.
Ma'am, I wasn't the judge that signed this. The court ordered you to follow this order. Do you understand that?
Yes, I understand that.
Oh, I passed the witness, I'm sorry.
Just a few follow-up questions. So, Ms. Hill, this order that the defense attorney went through, kind of page by page to the jury, the date of this order and the day it was signed, and he kept saying, this court order. Did you hear him say that? This court order.
Yes, according to the paperwork.
So this court order is, the agreed beginning said what? July 22nd of 2011. So about 11 months after your son was born.
Yes,
Is that correct?
that's correct.
And this court order, and he goes through, remember he went through this, read this out for the jury. Do you recall hearing
Yes.
all that?
Yes.
Okay. Is signed by the judge, by you and the defendant, July 22nd, 2011. Is that right?
Yes, that's
So-
correct.
And then the final order, court order, September 26, 2011. Do you see that?
Yes.
Okay. And then at the very end of your testimony, you said that he was saying that child support doesn't prevent or doesn't allow you not to, if you don't receive child support, there's other remedies, and you can't keep a father away from his son. Is that right?
Yes, that's right.
What happened between this defendant towards you after this order was signed?
Pretty much the same as it was before. It was just still issues.
And the protective order, which is also a court order, would you agree with me?
Yes.
Okay. The protective order that this defendant agreed to, what was the purpose of you getting a protective order against this defendant?
To protect me and my son.
Okay. Your Honor, may I approach?
Yes.
Okay, I'm going to show you what's been marked as State's Exhibit 391. Agreed protective order. Do you recognize this document?
Yes.
It has your signature. It has the defendant's signature.
Yes.
It references your son that you have with the defendant under Schedule A. It has his name and his date of birth. Is that right?
Yes, that's correct.
Okay. Your Honor, this time the state moves to introduce State's Exhibit 391.
No objection, Your Honor.
Order submitted.
So looking at this court order, the agreed protective order, 2012 CI 01103,
Yes.
the state of Texas for the protection of Sahara Paye Hill versus Otis T. McKane. Do you see that in Bear County, Texas?
Yes.
The date of this order, February 9th, 2012, is 5 months after this court order that the defense attorney went through with you?
Yes.
All right. And on here, it says specifically that the respondent, who's the defendant, respondent Otis T. McKane, do you see that?
Yes.
As his date of birth, it says, is therefore ordered that the respondent is prohibited from, and then it lists numerous things, including committing family violence by either, and it kind of goes through. But it says here, D is going within 200 yards of applicants of your home, of your place of employment, and the residence, so the home of the individual listed in Schedule A. So it says, and the residences, school, child care facility of the individuals listed in Schedule A. And when we go to Schedule A, I'm not going to put your son's name up on since he's a minor, up on the screen, but the jury can see who Schedule A is and who is listed in Schedule A.
My son.
Okay, the son that you have with the defendant, is that right?
Yes, that's correct.
And it has his date of birth, is that correct?
Yes.
Okay. And this protective order that the defendant agreed to, is that right? He signed it here on this last page? Or one of the pages, page 6 of 8?
Yes, it was signed.
His signature, your signature?
Yes.
That this protective order saying that the defendant cannot come to your home, your place of work, where your son lives, his school, or his child care facility, based on this protective order, expired February 9th. It was signed February 9th. It expires 2 years from the date of this signing. So February 9th of 2014. Is that correct?
Yes, that's correct.
I'll pass the witness.
Ms. Payet-Hill, if I may see that again. Okay, so the provision that the prosecutor is looking at is section D, right?
Is it B or D?
D.
Okay.
D, right? So it's very clear. It says that the respondent, which is in this case is Otis McKane, he's not allowed to go to the applicant's residence, applicant's place of employment, and the residence and school and child care facility of the individuals listed in Schedule A. And clearly your child is listed there. So in essence, it prohibits him from going to your house, to his school, and to this and that, right?
Yes, that's correct.
So it's locations. You agree with me on that?
I agree.
Okay. Nowhere here does it say for you not to follow the visitation order and take the child to him.
However,
Do you see, ma'am, I'm asking you the question.
yes,
Do you see anywhere here that it says you no longer have to follow the visitation order? It's not in here. Would you agree? I'll hand you the document if you want. Is that accurate, ma'am?
yes,
Okay. And so you'd agree with me, just generally speaking, that the visitation is still court ordered, as I stated through the papers I went before, even during the time of this protective order. You would agree with that?
yes.
I'm going to object to a legal conclusion. Your
What do you mean a legal conclusion? You want to read it?
I'm going to object to defense counsel's sidebar.
Pass the window.
All right, and so on State's Exhibit 391, it also prohibits the defendant from communicating directly with you or your son. Is that a fair statement by looking at that?
I agree.
Do you see that in B?
Yes.
I'll pass the witness.
If you keep on reading, leave it up there. You don't want it. If you keep on reading, very quickly, I want to make sure it does say, I understand, it says you're not to communicate in a threatening or harassing manner. You see that? Right here.
Yes. I
You're
see
not to
that.
communicate, and that's understandable, in a threatening or harassing manner. It doesn't stop the visitation order, right?
Right.
No further questions.
Nothing further from the State, Your Honor.
All right, ma'am, you're excused. Thank you. Does anybody on the jury require a break? All right, let's take a short break.
All right for the jury. You be seated.
stay away from COVID.
Can't blame
All
you.
these officers sitting there, I don't know if any of them are vaccinated. Breathing right on our necks. That's good.
All right, welcome back, members of the jury. State, you can call your next witness.
Your Honor, this one today calls Sergeant Mercedes Owens.
Have a seat. I'm going to swear you in. Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. If you could introduce yourself to the jury and spell your name for the court reporter, please.
Hi, my name is Sergeant Mercedes Owens at the Bexar County Sheriff's Office. My name is spelled Mircedeas. Owens, Owens.
All right, state.
Thank you, Your Honor. Sergeant Owens, how are you employed?
I'm the sergeant of the classification section at the Bexar County Adult Detention Center.
Okay. And how long have you been with the Bexar County Sheriff's Department?
Since 2013.
And what are your duties as a classification sergeant at the Bexar County Adult Detention Center?
Not only do I supervise the staff there, but also manage the caseloads of the inmates that are housed in the facility.
And the Bexar County Adult Detention Center, that's the same thing as what we commonly refer to as the Bexar County Jail.
Yes.
So you said in terms of classification of inmates, how are inmates classified?
So for starters, they're classified low, medium, high custody, and that can consist of being separated based on charges, institutional behavior, criminal history, things of that nature.
And when you say institutional behavior, that refers to what, ma'am?
Their conduct in our facility at the time they're incarcerated.
Okay. Do you know an inmate by the name of Otis McKane?
Yes.
Okay. And do you see him in the courtroom today?
Yes.
Would you please point to him and describe what he's wearing?
He's located to my left, and he's wearing a button-up shirt, black tie.
Okay. And for the record, you've identified the defendant, Otis McKane?
Yes.
Okay. Where is Otis McKane? Where is he housed at the Bexar County Jail?
He's located on the 6th floor of the Adult Detention Center in Unit Bravo Juliet.
And you talked about, initially with the jury, about the various classification levels. You said there's, low, medium, and restrictive?
High.
Or
Yes.
high? Is high the same thing as restrictive? Or?
Yes.
And what does that mean, high?
High can be based on their charges and institutional behavior.
Okay. And what types of charges would put an inmate or classify an inmate into the high status or the high housing?
Aggravated charges, murder charges, capital offenses.
Okay. And where is, you said the defendant is housed in Bravo Juliet. What is Bravo Juliet?
Bravo Juliet is a unit on the 6th floor that's considered our maximum kind of security. and it's composed of 20 cells.
And you said maximum security. Is there any other security, any other higher level of maximum security at the Bexar County Jail besides Bravo Juliet?
No.
Okay. And so there's two. There's nothing higher, but are there two units that are similar, Bravo Juliet and what BL? What is?
We have Bravo Lima, which is adjacent to Bravo Juliet, and then on the second floor we also have Bravo Charlie, Bravo Delta.
Okay. And so Bravo Juliet is on the 6th floor of the Bexar County Jail?
Yes.
And you said there's no other higher security units or security classification or living quarters higher than Bravo Juliet?
Right.
Okay. And so you said there are 20 cells in that particular unit?
Yes.
Okay. How is that unit separated from the other inmates or the other units at the jail?
So Bravo Juliet, it also has its own recreational yard. So the inmates that are housed in that unit, they have very, very limited access to be able to, unless they're going to like medical or court, they have very limited access outside of that unit alone.
Okay. And is anyone able to just, or either other inmates or guards, is anyone able to just freely walk into Bravo Juliet?
No, it's composed of a sliding door, and then there's also another door which the command center controls. So you can't just walk into the unit.
There's the initial door and
Right.
then a small vestibule, would you say?
Yes.
And then a second door that command staff controls?
So the command staff controls the pneumatic doors, the sliding doors that allow you access into that smaller vestibule, and then the living unit officers inside Unit Bravo Juliet, they're the ones that are able to control that gate that allows access into the actual living unit. So prior to entering the unit itself, where the inmate cells are, you have to pass through a pneumatic door and then also a vestibule.
Okay. And you said there are 20 cells in this particular unit of Bravo Juliet?
Yes.
And the cells, how many inmates are in each cell?
Single cell, one.
Okay, so there's no roommates?
No.
Okay. And why don't they have roommates?
For the reason of being, most of them are group alone, house alone, and just to allow like limited opportunity and confrontation or anything of that nature. All of the inmates in that unit, they come out by themselves, they do everything by themselves. There's no group activity in Bravo Juliet.
Okay. So is it usually full
Yes.
of 20 inmates?
Yes, ma'am. It could range from 18 to 20.
And the inmates, you said that they are not allowed to be with other inmates?
Right.
In the common areas?
Right.
Okay. That one inmate's allowed at a time?
Yes.
Okay. And why is that? Why aren't the inmates, if one individual's charged on this side with capital murder and another inmate's charged on the other side of the walkway, but within Bravo Juliet of another violent offense like murder or capital murder, why aren't they allowed out together?
Due to the type of offenses that are housed together, you try to eliminate that access of them being able to kind of group up together in number. Mm-hmm.
And you said that there's also a rec yard?
Yes.
Okay. Is it outdoor rec?
You can kind of get an outdoor breeze, not necessarily outside, but there is kind of like a gated gap, to where you can kind of get a breeze.
And so that outdoor rec yard is still located on the top floor at Bravo Juliet, but I guess at the end of the unit?
Right, so you have the living unit, and then you also have a door which allows access to the rec yard of Bravo Juliet, but it's attached. So you don't have to get escorted or anything of that nature.
Okay. Now, if a inmate leaves the Bravo Juliet, are they allowed to leave that particular unit unescorted?
No.
Okay. And they're only able to leave for what? You said medical?
Yes.
Or
they'll get escorted to medical or to attorney, maybe attorney visit, or and most of the times the ones for Bravo Juliet, we also have like the video or court.
Okay. Or to court.
Yes.
Okay. And how many guards are within Bravo Juliet?
2.
For the 18 to 20 inmates?
Yes.
And are there always 2 guards there?
Yes.
Has the defendant been housed in Bravo Juliet the entire time he's been in custody at the Bexar County Jail?
Yes.
And while he's housed there in Bravo Juliet, does he get to have video visits?
Yes.
Okay, and tell the jury what a video visit is.
The video visitation that we have available now is, now we have it's kind of like a portable kiosk for that unit and units like it, where depending on the type of or the time of the visit, the screen it's like a monitor with the phone that's attached so that they're able to communicate, and that can be transported, if they're not on their hour, that can be transported to each individual cell. And then the video visits are 20 minutes.
So they're allowed to have video visits while they're in their cell, is that right?
Yes.
Okay. So in addition to their hour out?
Yes, because sometimes every inmate's hour is not always on the time of their visit. And so with the tray slot, because all the cells in that unit in particular have tray slots, so the screen is in front of their cell, and then the phone cord is kind of funneled through the tray slot so that they're able to communicate.
And so the inmates in this, you said a high security unit?
Yes, ma'am.
Is that right? They are in their cell 23 hours a day?
Yes.
And then they have 1 hour for rec or the common areas?
Yes.
Okay. And what is the purpose of that?
The purpose is to limit, again, the opportunity and accessibility to the facility, and all of the inmates that are on administrative separation. It's always 23 hours in their cell and then 1 hour out to take care of their needs.
Okay. And those needs would be, to shower, to use the phone,
Yes.
is that right?
Yes.
And are they allowed unlimited phone calls?
No, it's not. As long as they have money on their account, and then they have the time allotted out for that hour.
So if they're out on their hour and they have time, they have money on their books, they're able to make as many phone calls as they like?
Yes.
And you mentioned that it limits their opportunity. What does that mean?
The limited opportunity, so the most that a inmate housed in Unit Bravo Juliet can, I guess, get into is maybe a verbal altercation. Not saying that physical altercations or anything other than that is prevented, but it just limits that opportunity for them to get into things.
It basically gives them no opportunity to have contact with any other inmates. Is that correct?
Yes.
Physical contact with any other inmates?
Physical contact, yes.
While they're housed in Bravo Juliet?
Yes.
And does it also limit then because it's such restrictive housing, meaning they're in their cell but all but 1 hour of the day, that there is almost no opportunities to have contact with other individuals for various Bexar County Jail violations
Right.
and such?
Yes, ma'am.
Okay, and why is that?
Just because each inmate comes out by themselves, there's no group activities at all, whether it's for the recreation yard or just merely gathering in the day room, which we call the common area. So it's just strictly by themselves at all times. There is absolutely no exception.
Okay. And this is that for safety reasons?
Yes, safety and security.
Okay. And safety and security of whom?
Safety not only for the inmate, but also the officer as well, and then security for the facility.
Okay. Now, since the defendant has been housed, you said there's very limited, housed in the Bexar County Jail, very limited opportunities to have contact with really anyone, right?
Yes.
Other than the phone calls or the video visits, but personal contact, right?
Yes.
Do they also have access to the commissary?
Yes.
Okay, and tell the jury what that is or how commissary is done at the Bravo Juliet unit.
So commissary is operated on it's like a kiosk where you can pretty much pick, the items are lined up, they have I guess you could say cashier kind of simulator, and when they approach Unit Bravo Juliet, they enter the pneumatic doors through the small vestibule area. They do not enter the actual living unit where the inmate is housed. They stay outside that gate that I spoke of earlier, and then they complete the transaction that way.
Okay. And so the commissary, they have access to what at the what do the inmates have access to in terms of purchasing at the commissary when it comes to Bravo Juliet?
Hygiene, writing materials, and then also the snacks like the food, the chips, the soups.
Any radio, television?
They do have the opportunity to purchase a radio. However, no television is offered on the commissary card.
Okay, so they can purchase a radio, and then they have all the candy, chips,
Yes.
stuff like that that's offered at other commissaries, right?
Yes.
Okay. And was there an incident between the defendant and the commissary lady?
You're going to check this hearsay.
At this point, that's sustained, you could lay a foundation.
Well, do you have personal knowledge of an incident that occurred between the defendant and the lady who was selling commissary on Bravo Juliet?
Yes.
And can you tell the jury about that particular incident?
So the incident that I have knowledge of occurred on, McCain was written up on a discipline for not receiving the commissary lady. He cursed out the commissary lady for getting his order wrong. And then after further investigation done by the initial supervisor, it was determined that he was charged under another inmate.
That he was what, I'm sorry?
That he was charged for pretty much the amount of money that was charged was not correct under his account.
And so that's why he cursed out the commissary lady?
Yes, as the documentation says, yes.
And so she's behind bars, is that correct?
Yes.
So he couldn't do anything to her, is that right, physically?
Yes.
For her protection, she's not allowed to walk into Bravo Juliet.
Right.
Okay. And so, do you, since the incident that, after the jury found the defendant guilty last Monday, has things changed in terms of the defendant being escorted out of Bravo Juliet to court?
Yes.
Has the security been heightened around the defendant, Mr. McCain?
Yes.
Can you tell the jury about that?
So the heightened security is, it's composed of the CERT team. It's a code 11 where instead of him just being escorted by one officer, now he's being escorted by the CERT team, which is composed of 5 officers and then a team lead, which is a total of 6. And then they escort him down to booking, which is where he would be picked up to be transported to court.
Okay. And so prior to that, what had changed besides the jury's verdict? Was there something that occurred that has heightened security involving this defendant?
Yes, the physical incident that took place in court.
Okay. After the guilty verdict, when the defendant assaulted the deputy or the bailiff?
Yes.
Okay. And so now, instead of being escorted by, how many guards used to escort him?
Just one.
Just one from Bravo Juliet to the booking area to
Yes.
be transported, and now there are 6?
Yes.
I'll pass the witness.
Sergeant Owens.
Yes.
Okay. The jail makes these decisions on where an inmate's going to be housed when they come into the jail based on their charges,
Yes.
and also based sometimes on how high the bond is.
Yes.
So somebody can come in there under an offense with a high bond, and they will also have this restricted custody.
Yes.
Okay. And this section of the jail you've been describing, is it just these, what you're calling high-risk inmates that are housed there, or other types of inmates also housed there?
High-risk inmates that are housed there.
Pardon?
Yeah, high-risk inmates that are housed there.
Okay, like mental health issue inmates, are they ever housed there?
It could be, they could have mental health issues and be high-risk, yes.
And what about like an inmate who's been put into some kind of, we'll call it protective custody? Or sometimes they housed up there as well.
It's rare, but it could happen.
Okay. And now, talking about this incident with the commissary lady, I'm not exactly sure how the jail is set up where these inmates in this unit get their commissary. Could you describe it a little better for me? I mean, just so I can picture it.
Yes, so the pneumatic door, which is the sliding door, that's controlled by master control. And then once you enter that, there's a vestibule. It's a good size to fit the commissary car, officers, But before that, you'll have the officer station, which is located outside of the living unit. However, there's a window, and then connected to that window is that sliding gate that I was talking about, in which the unit officers control. So whether it's medical or commissary, when they come into, before you enter the living unit itself, where the inmates can shower and have their rec yard and their day room access, you have to enter that vestibule.
Now, when it comes to commissary, would you tell, how does that work? How does an inmate get to have commissary?
So for starters, of course, money on their account, and then when the commissary card comes, they typically, housed in the high-risk units, they typically fill out a form sometimes, but then even once they come to the card, if there's something else that they want, they're able to order that as well.
Okay, and so it's like having a bank account with the jail,
Yes,
and people on the outside can make deposits into it.
yes,
Okay, and do you find that in the jail, inmates are very protective of their commissary accounts?
very, yes,
And so if someone's commissary, if whoever's running the commissary charges someone else's commissary on another inmate's, he'd be upset.
yes,
Okay. And so what we're talking about is that's what happened to Otis McKane.
yes,
A charge was made on his commissary for something somebody else got.
yes,
And so he called the woman a name.
yes.
And he got what kind of, how much privilege did he lose for having done that?
I believe it was 5 days, lost of phone visits, commissary.
Okay. Now you said you had personal knowledge. You heard him say that to her?
I did not hear him, but I am
Oh,
the,
then you don't have personal knowledge. I have no more questions. Thank you.
You said you were the, I'm gonna let you finish what you were saying, Ms. Owens. You're the,
the custodian of record for these documents.
okay. And the defense counsel asked you, are there other inmates in this high-risk unit, Bravo Juliet, that are mental health inmates? Is the defendant housed in Bravo Juliet as a mental health inmate?
No, ma'am.
Okay. Is he housed in Bravo Juliet as a protective custody inmate?
No.
Okay. Why is he housed there?
He's
That's
housed,
just repetitive. That's been asked and answered.
I'm responding to his questions about the high-risk inmates.
She's already testified to that. I was here, Judge. Even with my deafness, I heard it.
Overruled.
You can answer.
he's housed there due to his charge and then the case being high profile.
I'll pass the witness.
But before the defendant was convicted in this case, and before the security around him was heightened, did he ever go to medical?
I'm sure I don't have those records on hand.
Did he ever, so you don't know if he did or not?
No.
If he did go to medical, would he be around other inmates?
Yes.
And if he has an attorney visitation, he's escorted down to that part of the jail, correct?
Correct.
But then he's around other inmates who are also waiting for attorney visitation.
No, ADSEG inmates are not left alone. So once he,
If this has been going on,
I'm going to object to defense counsel not letting the witness answer the question.
go ahead.
Ask your next question.
can you repeat the question, please?
I don't remember. Oh, well, yeah, I was trying to find out, when inmates are brought down for attorney visitation, there are a lot of inmates standing around back there, waiting to visit their attorneys.
Not necessarily. When we have the attorney visits, sir, the ADSEG inmates, they're called down according to like whether they need escort or whether they're general population. So we don't just have a lot of inmates standing around waiting for attorney visits.
Well, but you're saying it would never happen?
I didn't say it would never
Oh,
happen.
okay, so it does happen then. All right. I have no other questions, thank you.
I have nothing further. Thank you, Sergeant Owens.
Yes.
All right, thank you.
Yes, sir.
All right, State, call your next witness.
The state calls Tiffany Bridges.
Yes. Since you're a witness, you can have a seat. I'm going to swear you in, okay? Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. You may need to adjust the microphone. Make sure everybody can hear you. If you could introduce yourself to the jury, please, and spell your name for the court reporter.
Tiffany Bridges, Tiffany Bridges.
All right, State.
Thank you, Your Honor. Ms. Bridges, can you tell the members of the jury what you do for a living?
I'm the video visitation supervisor for Bexar County Detention Center.
Okay, we just heard from previous witness that video visitations are roughly 20 minutes in length. Is that correct?
Yes.
Okay, and as the video visitation director for the Bexar County Jail, do you keep records of the video visits? Are y'all required to keep those records as a regular part of your business?
Yes.
Okay, and when the video visitation occurs, are you required, or those visits required to be recorded at the time that they occur?
Yes.
Okay, and is it the regular part of the business practice of the Bexar County Jail to keep these video visitations?
Yes.
Okay, and may I approach the witness, Your Honor?
Yes.
Ms. Bridges, were you requested to look at a video visit from April 4th, 2018 regarding an inmate by the name of Otis McKane?
Yes.
Okay, and let me show you what's been marked for identification purposes as State's Exhibit 392. Can you take a look at that and tell me what that is, please?
That is a CD and my signature is on it with the date
Okay.
and the name.
And the date, can you tell the members of the jury what date was that video visit for Otis McKane?
4/4/18.
All right. Now, let me hand you what's been marked for identification purposes. And State's Exhibit 392, was that the full 20-minute visit on State's Exhibit 392?
Yes.
Okay, let me hand you what's been marked for identification purposes as State's Exhibit 392A. Can you tell me what that is?
It's an identical CD with the date 4/4/18 on it and my signature.
Okay. And did you view 392A?
Yes.
All right. And is 392A a redacted version or a smaller version of the 20-minute visit on State's Exhibit 392?
Yes.
And is 392 and 392A, can you tell whether or not anything has been changed in those visits or any additions or deletions to that 20-minute visit?
There wasn't anything changed.
Okay. Thank you. Your Honor, at this time, we'll offer into evidence State's Exhibit 392A.
Yes. Thank you, ma'am.
All right, State, call your next witness.
The state calls Sylvia Castillo.
I'm going to swear you out. Okay? Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Adjust the microphone at the base there. You can remove the face covering for the purposes of testimony only. If you can introduce yourself to the jury, spell your name for the court reporter, please.
Hi, I'm Sylvia Castillo, SYLVIACASTILLO, and I work for IC Solutions.
State.
Thank you, Your Honor. Ms. Castillo, what is IC Solutions?
We handle communication services for phone and video for the Bexar County Jail.
And when you say phone services for the Bexar County Jail, are the inmates allowed access to make phone calls from the jail?
Yes, sir.
And how are those monitored? When an inmate makes a call from the jail, how do you know that a particular inmate is making a particular call?
They have to enroll into the phone when they're booked in. They have their SID number that's assigned to them by the facility, and then they get on the phone and select a 4-digit passcode. And once they do that, then they have to enroll into the phone. They read a verbiage until the system can get enough of their voice to match that voice with their PIN number, which is their SID number plus the passcode they selected.
And as the custodian of records for the phone calls for the Bexar County Jail, are you required, and is the Bexar County Jail required to maintain these records as a regular part of the business practices of the Bexar County Jail?
Yes, sir.
And are the phone calls recorded at or about the time the phone call occurs?
Yes, sir.
Okay. And are they recorded by in such a way that you or somebody with your company can tell, yes, this is an actual phone call made by this particular inmate?
Yes, sir. The minute the phone goes off hook, the system starts to record and capture everything, unless it's an attorney call or a privileged call.
And were you asked to listen to some phone calls by a Bexar County inmate by the name of Otis McKane?
Yes, sir.
For this case, for this trial?
Yes, sir.
Okay. May I approach the witness, Your Honor?
Yes.
May I approach, Your Honor?
Yes.
Ms. Castillo, I'd like to hand you what's been marked for identification purposes as State's Exhibit 393. Can you take a look at that and tell me if you recognize what that is?
Yes, sir.
And what is that?
It's a call recording of the CSN from
Okay.
Mr. Otis McKane.
And how do you know it's a call for Mr. Otis McKane?
I listened to the call and initialed and dated the
Okay.
CSN.
And State's Exhibit 393, is that the full 20-minute call that you listened to for Otis McKane and on the date of July 27th, 2021?
Yes, sir.
Okay. And so Mr. McKane was convicted by this jury on July the 26th, 2021. So this call occurred the next day. Would that be correct?
Yes, sir.
Okay. And let me hand you what's been marked for identification purposes as State's Exhibit 393A. Can you tell the members of the jury what 393A is?
It's a call dated July 27th. I did listen to this and initialed and dated as
Okay.
well.
Okay. Thank you.
You're welcome.
Now let me hand you what's been marked for identification purposes as State's Exhibit 394. Can you take a look at that and tell the members of the jury and the court if you recognize that?
Yes.
And what do you recognize that to be?
This is another call recording from July 27th.
Okay. And is that for Otis McKane?
Yes, sir.
Okay. And how do you know that is?
I listened to it, initialed and dated it.
Okay. And the date for that call, can you tell us what the date for that call is?
July 27th, 2021.
Okay. And so, once again, one day after he was convicted.
Yes, sir.
Okay. Now let me hand you what's been marked for identification purposes as State's Exhibit 394A. Can you tell us what that is?
Yes, a call recording. I initialed and dated it as well, July 27th, 2021.
Okay. And is 394A just a redacted version of 394?
Yes, sir, it is.
Okay. Thank you. And lastly, let me hand you what's been marked for identification purposes as State's Exhibit 395. Can you look at that, Ms. Castillo, and tell the members of the jury if you recognize that?
Yes, it's a call dated August 1st, 2021. I did listen to it and initial and date that as well.
Okay, and is that the full text of the call?
Yes.
Okay, and let me hand you what's been marked as State's Exhibit 395A. Can you tell us what that is?
Yes, it's the redacted version of the August 1st, 2021 call
Okay.
that I did sign and date.
So you viewed that, you signed and dated it?
Yes, sir.
Okay, and that was 2 days ago, 2 days prior to today.
Yes, sir.
And that's a redacted, 395A is a redacted version of State's Exhibit 395.
Yes, sir.
Okay, thank you. Your Honor, at this time we'll offer into evidence State's Exhibit 393A, 394A, and 395A. Appended in the counsel.
Can I take the witness over now?
Yes.
It's Sylvia Castillo, correct?
Yes, sir.
Okay, and I'm running folks. How you doing?
Fine, thank you.
Okay. And who did you say you work for again?
IC Solutions?
Okay, and that's who basically has the phone service with the jail, right?
Yes, sir.
Okay. And exactly what is your position at that company?
Director of Client Services.
Oh, okay. Now, you stated that these exhibits are something you've listened to.
Yes, sir.
And you say that based on that, you're able to identify the voice on here as belonging to Otis McKane.
Not the voice, sir, it's the process. When they enroll into the phone, they have to set up their PIN number, which is their SID plus that passcode, and the system will have them read verbiage, and once it captures enough of the voice, it matches the voice with that PIN number. And the only way they can make a call is if they enter that PIN number and the voice matches. It asks them to say their name, and if everything is good, the call will go through.
Okay. You personally have never spoken to Otis McKane, though?
No, sir.
So you wouldn't recognize his voice if you heard it?
No, sir.
Are there, you've listened to these recordings, are there other voices on these recordings?
Other voices than Mr. McKane?
Right.
From the people that he's speaking with?
Okay, and you know who they are?
No, sir.
You're not able to identify them?
No, sir.
Okay. I have no other questions, Your Honor.
I have another question, Your Honor. Ms. Castillo, the individual who's making these phone calls on all three of these, who does that individual identify himself to be?
Otis McKane.
Thank you.
We
We re-offer. 393A, 394A, 395A.
We have the same objections we made at the bench to the other parties, Judge. Additionally, under Edwards versus States, that these don't qualify because the voices have not been identified.
That's incorrect, but we can wait.
Judge,
She doesn't need to.
What are you gonna say?
We said, Judge, you can review these and make a later ruling if you want it at that time, instead of having a hearing outside the presence of the jury.
Okay. Well, I overrule the other objections. I overrule these. I'll admit them.
Okay, and just to make certain then, on the video visit, Your Honor, the video visit is admitted also?
Yes.
Okay, thank you. Ms. Castillo, thank you very much. We have no further questions.
Thank you.
absolutely, thank you.
Thank you.
Thank you, ma'am. All right, State, call your next witness.
State calls Mark Machado.
Okay.
Oh,
He's walking down the hall, Judge.
Okay. All right, you've already been sworn. You've already testified.
Yes, sir.
State.
I'll give you a second to catch your breath.
Thank you. I didn't get the phone call.
Welcome back, Mr. Machado, for I believe the third time, I think.
Yes, ma'am.
But today I want to talk to the jury about knowing Benjamin Marconi as a fellow officer. You were with the force for 25 years, or 27.
25. I came on the year right after Ben did.
So during those 25 years, did you have the opportunity to come to know
Yes.
by your presence to give us a few moments.
All right, Secretary.
Should I excuse the witness, please? Just let
I need to clarify something. Well, I just need to clarify something. Who was speaking? Mario, you said Payne versus Tennessee, and then someone said there's also Booth versus Maryland. Was that you, Danny? Thank you. Let me just put that in there real quick because I couldn't tell who that was. I am ready.
All right, let's proceed. The jury's out of the courtroom. State, you want to proceed? What evidence do we expect to come out with this witness?
I'm going to let them proffer that.
just some experiences that Mr. Machado had with Detective Marconi while on duty. Some things they worked together, his interaction with certain communities.
What would be the 404 relevance?
So, it's our position that victim impact testimony per the CCA and the Supreme Court is admissible, both the future danger, because it is foreseeable that the defendant's conduct will have an impact on the close friends and family of the deceased. Furthermore, it goes to mitigation, whether there is evidence that would otherwise suggest that a life sentence is appropriate. So it's relevant to both. I can get the court cases when you give me a few minutes to print them up.
I'll give you a few moments to print that out.
But there's also case law that says that admission of victim impact that doesn't directly relate to the crime is not admissible. So I guess what we should do is hear what the officer or the CSI personnel men would talk about, and then testify to it, and we can go from there as to what our objections would be.
Oh, Judge, and I thought I heard him say that it goes to the future dangerousness issue as to the impact on Officer Marconi's family, and that the information about Officer Marconi goes to whether special issue number 2, whether there's mitigation on behalf of the defendant, Your Honor, and I don't follow the logic of that.
Your Honor, if you take the time to read the cases, and I would urge you to read whatever cases they're going to present, you'll see that their position is incorrect. Victim impact is admissible. Benjamin Marconi is not in this courtroom. The Supreme Court has said this is the opportunity to humanize Benjamin Marconi now that he's been convicted. And it goes not only to the future dangerous issue, it also goes to the mitigation issue. And Payne v. Tennessee, I think, is probably the seminal case, but we'll provide you with the cases. And I would like to, if the defense could give us a copy of the cases they're talking about so we can read them, I think that would be enlightening to everybody.
Or at least the citations, we can look it up.
Well, we hadn't anticipated that the state would try this, Judge, so we didn't have the cases prepared for the court.
That's what I'm saying, as long as you give me the
Yeah,
citation.
We'll give you the citation.
Yeah.
But additionally, Judge, this is also where the prosecutors have requested a charge to be given the jury that they're not to base their decision on any kind of sympathy or anything like that. That's purely what this is. It does not go to either of the special issues.
Judge, if you read the case law we're going to get for you, it goes directly to humanizing the victim who was murdered in this case, and we'll provide that to you.
Okay. I might as well start looking now. Defense, you got that
Yes,
citation?
Your Honor. Booth v. Maryland is 107, Supreme Court, 2529.
I'm sorry, I couldn't hear you.
Bosse, B-O-S-S-E versus Oklahoma, is 137, Supreme Court 1.
Your Honor, just for, I just looked on Westlaw. Booth v. Maryland was specifically overruled by Payne v. Tennessee, as per Westlaw. And what was the other case you cited?
Bosse versus Oklahoma, 137, Supreme Court 1.
Well, that's this.
So the bailiff just advised me that one of the jurors has an emergency situation at the house. They got to go. So I told them all to return at 9. Meanwhile, we'll deal with this issue.
Danny, what was the site on Bosse and Bosie?
137, Supreme Court 1. It's a good one.
It has to be overturned.
So I'm reading Payne. Payne seems to be a little more expansive.
In that case, Judge, with the jury leaving, Mr. Machado, get off the stand.
Oh, yes.
I mean, we could keep him here, but.
All right. See you tomorrow, CSI. 9 o'clock.
Yes, sir.
9 o'clock.
You just caught your breath.
Well, Payne seems to be pretty clear.
We're looking at Bosse.
Okay.
Judge, reading Bosse v. Oklahoma, that's a completely separate issue. That's where the victim family members were asked to characterize and give opinions about the crime and the defendant and the appropriate sentence. That's completely different from what we're attempting to do with victim impact testimony.
We don't know what you're trying to do. We don't know what you're trying to do with Mr. Machado.
Well, if you know what victim impact testimony is, you know what
Well,
you're
no,
trying
but
to
we
do.
don't know what you're gonna do. We don't want you to do it.
You held out to the court that this case stood for a proposition it does not.
It does.
Well, what are you gonna
Yeah.
do? What are you gonna do? What they did in Booth? We don't. In Bosse.
Booth has been overruled by
Listen,
Payne
in
v.
Bosse,
Tennessee.
how do we know you weren't gonna do what they did in Bosse? How do we know? How do we know? We don't know. That's why we had Machado. We wanted to do a proffer, do it to the court, and then whatever
And
you
we can
ask
decide
them.
whether it's.
My point is, that's not what you cited this case for the proposition. You cited, first of all, you said victim impact testimony wasn't admissible at all. That's what you told the court, and that's wrong. Okay? And then you said this wasn't admissible for that reason, and that's wrong too.
All right, well, I disagree.
Getting it on the record.
I'm on the record, yes.
All right, and so the proffer, let me make sure I completely understand the proffer. What exactly is the witness going to testify to?
He was going to talk about 3 incidents he had while working with Detective Marconi, as well as his knowledge of Detective Marconi's interaction specifically with the Alizé courts.
Well, yeah, but like what? I mean, a bunch we'd like
Like,
to know.
just that he was beloved by the community over there, that he would check on the mamas, that the kids always ran out to him to speak with him, just that he would bring them toys on occasion, I believe, as well. As we know, this is a very underserved community over there. And then he was maybe going to talk about, but it may come through one of our other witnesses, about Benjamin Marconi's commendation in the 1998 flood.
In the 3 incidents you're talking about, just as
Like
a problem.
that was the Alizé, that, and then the flood, and then he has one additional that we might go into just about what a hard worker
His
he was.
personal
with
experience
them.
working
Yeah, his
with them.
personal experience. And obviously specifically to his work as an officer.
Right, I'm gonna overrule the defense objections. Anything else? If the jury was here, I'd bring him back in, but,
Yeah.
all right, so
So we're
tomorrow,
also going to have family members testify. We're going to have it, so in case I don't want to surprise the defense, but we have family members, 2 family members testifying, and then a police officer that was Detective Marconi's sergeant at the time in the SVU unit, talk about his work and what he did within the unit.
well, you know, if we're gonna have objections, we might as well take care of it now. Right, so, y'all wanna talk about that real quick?
And you want to talk about it and then proffer to us and then say,
Yeah,
for
right.
us to powwow, if you will? Or you
Yeah,
want to-
no, I'd rather y'all powwow and you let me know, so if there's any objections, we could resolve it now while the jury's not here. And
Okay.
it's
Are you okay with that?
4:40.
What's that?
He wants us to just sit with them and for them to give us a proffer about, there's 2 other third
Yeah, yeah,
members and an officer that are coming testify.
And I'm going to bring photos into the family.
Yeah, we're still gonna, just in case we got out
You want him?
in chambers talking. Yeah, they're going over the proffers.
They're actually working.
I know, we're like, are we?
They're on a coffee break. They probably got,
Yep.
pastries and pan dulce, all that stuff back there. I hope the pan dulce was good.
I don't like pan dulce.
I'm not a pan dulce.
I'm not either.
Yeah, I'm not.
Well, it depends on what it is.
Now I can eat barbacoa until the cows come home.
All right. Here. I will say this trial has sharpened my exhibit organizational skills. I am at the top of my game with exhibit organizational skills. So thank y'all.
You've done a great job, without a doubt.
No, really, I have. I mean, like, I have, but no, I have gotten a good system for future trials, and I've been doing this for almost 30 years. But I don't think I've ever dealt with this many exhibits.
All right.
Y'all ready to go back on the record?
We can just have Ray and Tamara over here.
Oh.
They're AWOL.
We're talking about.
About the victim impact.
Oh.
He worked in New York for 3 years in Paris. What are we doing now? Okay. You got this down?
Yeah, yeah.
Okay.
All right.
Okay.
All right, back on the record, State of Texas versus Otis McKane. Jury is not in the courtroom. Present are the attorneys for the state, attorneys for the defense. Now, the defendant is not in the courtroom. Is that right, defense?
We waive his presence, Your Honor, for purposes of this hearing.
Okay. All right, what do y'all have?
Judge, we've conferred with the state. With regards to Officer Machado, we would object to his testimony as not being victim impact. He's not a family member. He's not been impacted like the family. And if the court overrules that, there is a portion of his testimony that goes to that Officer Marconi helped them, where detectives typically do not assist CSIs to, search a place or whatever, and that Officer Marconi went beyond the call of duty or whatever to help him because it was a sexual assault and he wanted to get the guy. Marconi did. And so we feel that that's not proper victim impact, even if the court does allow Officer Machado. Officer Machado, the proffer from the state, and I can stand corrected, is that he was very helpful with the courts on different instances, and also that during the '98 floods, I believe, he saved an individual from drowning. Those are the other parts that Officer Machado would discuss. The state has also proffered that they're going to call family members that will discuss what we believe is proper victim impact, and that they will instruct their witnesses not to go beyond admissible impact statements. So we will rely on the good faith representations of the state.
And also, to be clear, so that the rest of it's addressed, the state is also planning to call Sergeant Mike Davis, who was Detective Marconi's supervisor at the Special Victims Unit. So his testimony will go to how he performed his job, and he may have a story or two to tell the jury about Detective Marconi, but it's his relationship with him as a supervisor, and then how what occurred after his death in terms of the unit.
Like maybe didn't hear what occurred after Marconi's death in his unit or to that individual?
No, I mean just the somber nature of after Detective Marconi's death. Like the cases kept coming in, and officers still had to keep working, although they were had just lost one of their own, and they're having to just continue to go forward. So he just wanted to address that point as well.
Let me ask the defense. Are y'all going to? I mean, you guys want the mitigation special issue in the charge, is that right?
The mitigation special issue in the charge?
I know it's an unusual question, but it's a question.
Yes, of course, yes, you are.
Okay.
Yes, we do.
Okay, I'm just making sure.
Yes.
And you also want the future. Well, you also want the other special issue.
I don't know if we can waive future danger.
Yeah.
I think the court was looking at the Williams case, and I think that was the crux of it.
I'm sorry.
Oh, I'm sorry. The crux of Williams was when you have a stranger victim, the victim-defendant relationship is that of strangers, then the CCA is saying victim impact evidence cannot come in for the purpose of future danger. But in that case, what they were discussing is it would be wholly disallowed if the defendant were to waive the mitigation issue. Thus, it can't come in under future danger, and because the mitigation issue is waived, there's not that path to relevancy through that issue. But here, if we have the mitigation issue, the jury's going to answer that. Then calling two people from the San Antonio Police Department who worked with him, we believe that would be relevant to that issue.
To the mitigation issue?
To the mitigation issue.
And we just disagree, Your Honor, for whatever it's worth, that again, victim impact and the way they were impacted is more for family. And we don't believe that in the mitigation issue necessarily gives rise to these two officers testifying.
Okay, so State, you've already proffered what the two officers would testify to. Based on that, based on the case law that has been presented to me, I'll overrule the defense objections and allow that testimony. Anything else?
Well, the other good faith representation from the state is that family members will testify about appropriate victim impact, and that they will instruct those family members not to go beyond the proper bounds of that. They also have shown us some exhibits, some photographs that they intend to introduce. We looked at them. We believe they're proper.
Except for the one with the puppy.
They're proper.
Any response to that?
If they're saying they're proper, then I agree with them.
Okay.
I agree with what Mario said earlier. We have, the case law says we get to, at this point, show the jury who this deceased individual is. And that's what we will do now.
I guess if we record this real clear, we already objected to any kind of victim impact testimony. We believe the court then instructed us to go work something out with the state, believing that the court was going to admit the evidence, which the court has not done.
Right.
So we have not waived any of those prior objections. Okay, but we're still objecting to any victim impact testimony as not being relevant to the two special issues the jury has to answer.
Right. So then I'll overrule the 404 objections on that. What was the proper bounds that y'all were talking about? The proper bounds, as long as the state stays within the proper bounds of what we discussed.
I think something along the lines that they cannot say anyone what they want to happen to the defendant.
Oh, right. And state you're in agreement with that.
Yeah,
We are.
no,
We're in agreement.
no opinion on their personal feelings about what should happen either way,
Right.
unfortunately for us.
Right. That's our agreement. I mean,
Okay.
Obviously, that's the law. So.
And while we're here, sometimes the defense tries to get into defense impact testimony. So, and I'm just saying, that is
Tell me how I do that.
That is inadmissible.
Please tell me how I do
I didn't say you. I said the defense sometimes. Quit being so sensitive.
Well, I'm
Man.
going to do it.
Yeah. But anyway, if we have to, we'll go into that. But defendant impact testimony is inadmissible. But we can address that if they try to get
Well, what happened is it's good for the goose, it's good for the gander jazz.
That was a different farm.
All right, anything else before we break?
Not from
No, Your Honor, only housekeeping, the state has also mentioned that they think they're going to go in most of the morning now with what we have, and we have to leave you have to let the jury go because of the emergency early. And so if the court would allow us to get ready for right after lunch.
Okay, we'll do that.
Okay.
So a defense case will start after lunch.
Yeah, but can we figure that out too, about the witnesses?
Which is?
Like we got the doctor from Dallas and we need to...
Yeah, well, I mean, we talked about that.
We don't want to stretch this out any longer than anybody else, Judge, but we're trying to figure out exactly what our time is and how we can finish this trial this week.
Oh, I was thinking Thursday.
Well, we think that if we start tomorrow,
At 9 o'clock.
Well, no. Yeah,
9 o'clock.
The state goes to the morning, we start the afternoon. We should be very close to finishing on Thursday. We are going to put an expert on it, we've told the state. And so I imagine they're going to have rebuttal. The question is how long that takes on the fight of the experts.
Tomorrow's Wednesday.
Okay, so I'm supposed to get a root canal Friday. I cancel that. I alter that.
Tomorrow, they go
Looks
morning,
like
we go afternoon when
Right.
they witness.
And it's Thursday morning, we would have Crowder here.
If we finish with our legal, if we finish.
Yeah, I'll
with our-
cancel.
It sounds like they're gonna finish Thursday.
Well, he's
but
coming
I
on anyway
can't,
Thursday.
I can't speak to potential
I just
rebuttal.
want to make sure.
Right.
Well, I mean, if they have Crowder, then we're going to put on, at a minimum, Dr. Fabian, and we may put on another, depending on what Crowder goes into, we may have another rebuttal.
Okay. So no root canal for me this week on Friday. I'll postpone that again.
Well, that won't happen if they don't put on Crowder. We're good.
Oh no, I'm good. It's like I'll suffer through.
It's a lot of good drugs.
Yeah,
It's a
okay.
a re-root canal. Correct a bad one.
My wife just said that.
Yeah, I'm not looking very favorably at dentists at the moment.
In my, not on the record, Judge,
Well, not
but
yes.
we discussed potentially ending the live stream.